Welcome back to Counting to Five, a podcast about the United States Supreme Court. I'm Mike, your host. This is our weekly YouTube live stream being broadcast live Thursday, May 31st, 2018 at 9 p.m. Eastern Time. This live stream will also be posted as an episode of the Counting to Five audio podcast. And in these weekly live streams, we try to keep up to date with the latest Supreme Court news. If you're watching live, please feel free to ask questions in the YouTube live chat at any time, and I'll try to keep an eye on it and answer questions as they come up. So here's what I plan to cover today. We're rapidly approaching the end of June, which is the court's self-imposed deadline for issuing opinions in all the terms cases. But the court continues to proceed at a snail's pace of opinion issuances. This week, on Tuesday, May 29th, the court issued opinions in only 2 argued cases and also dismissed a 3rd case without an opinion. I'll spend the bulk of this episode discussing each of those 3 cases. But before we get to that, first, a few developments in some other cases, developments this week. The first is a case called Culbertson v. Berryhill. Now, this is a case that the court granted just last week. And I talked about this case and gave a little summary of it in last week's live stream episode. This is a case that involves the cap on attorney's fees, a statutory cap on attorney's fees for lawyers who are bringing challenges to denials of Social Security benefits. Now, when I talked about this last week, I mentioned that when the case got to the Supreme Court, the government switched positions. The Social Security Administration, which had been opposing the lawyer's efforts to get higher fees, now agreed with the attorney before the Supreme Court and agreed that he was entitled to the fees that he was seeking. And the government, in its brief in response to the cert petition, suggested that the court should appoint an amicus curiae, a friend of the court, to defend the decision below. And that's the court's typical practice in these circumstances. When you have a situation where a lower court rules in favor of some party or other, and when the case gets up to the Supreme Court, neither party is willing to defend, at least willing to defend the rationale or the reasoning that the lower court used. Here, the government's not even doesn't even support the outcome of the lower court. The court will often appoint an amicus and just an outside attorney to come in and defend the reasoning of the court below, just to basically give a full airing of the different positions that have been expressed in the case. I guess the idea is if a lower court actually, this is one of the federal courts of appeals actually issued an opinion endorsing this view, then the court feels it's at least worth its time hearing that argument and hearing out the position that the lower court adopted. So what happened was last Friday, that's May 25th, the court did issue an order inviting an attorney named Amy Weil to brief and argue the case in support of the judgment below. Now, Weil is an attorney with a solo practice in Atlanta, Georgia. She worked for 25 years in the U.S. Attorney's Office for the Northern District of Georgia, including 18 years as the chief of the appellate division. She's apparently very active in bar activities related to the 11th Circuit Court of Appeals and appears to be widely respected with extensive appellate experience, though it doesn't appear that she's ever argued a case at the Supreme Court. She seems very well qualified for this kind of an amicus appointment. However, unusually, unlike many of the appointed amici, she's not a former Supreme Court clerk. The invited amici, the amicus, the arguers, they're typically selected by the circuit justice for the jurisdiction the case came from. Now, this case came out of the 11th Circuit, and the circuit justice for the 11th Circuit is Justice Thomas, Clarence Thomas. Now, the circuit justice is just a justice who's assigned to a particular circuit that's a jurisdictional region of the country. And that circuit justice has certain limited oversight responsibilities with respect to that circuit. Most significantly, that circuit justice has kind of the first pass review of emergency applications to the court. For example, stays of lower court opinion decisions and things like that. So Justice Thomas is the circuit justice for the 11th Circuit. And often in these cases, these justices tend to appoint one of their former clerks to take on the argument. But Justice Thomas, this kind of fits. He has a history of, in his hiring of clerks, of looking beyond the typical elite credentials, for example, degree from Harvard or Yale law schools, in hiring his law clerks, and kind of reaches more broadly than many of the other justices do. And it looks like he took a similar approach here, looking to a broader pool of potential attorneys than just his own former clerks. So Amy Weil will get an argument before the Supreme Court, and she probably has a uphill battle here, given that all the parties in the case are now on the other side, opposed to the position that she's been appointed to defend. But we'll learn more about that case as it becomes briefed. So moving on from there, there's two more orders this week I want to talk about briefly. These are both orders where the court provided no explanation for the particular action, and court watchers are left to just speculate about what's really going on, but I'll take them each in turn. Now, the first, I mentioned above that in addition to issuing opinions in two argued cases, the court also dismissed one argued case without an opinion. This is a case called City of Hays, Kansas v. Vogt. Now, this case was dismissed as improvidently granted, or just the kind of the short Supreme Court jargon for that is the case has been dig for dismiss as improvidently granted. When a case is digged, it's basically as if the case was never granted in the first place. It's just it kind of undoes the court's grant of the writ of certiorari, and the case goes back to the lower court just as it was before the court stepped in to take it in the first place. Usually when this happens, these digs, it's usually due to what's known as a vehicle problem, which in other words, the case is the court believes that the case is a bad vehicle for deciding whatever legal question the court granted the case to resolve. The order itself doesn't give any information. The full text of the order dismissing the case just says, the writ of certiorari is dismissed as improvidently granted. And that's it. No further explanation. So just to give a little more background with this case, the basic facts of this case involve a police officer in Hays, Kansas named Matthew Vogt. Now, he was subject to an internal investigation in his police department over alleged misconduct, and he was required to participate in that internal investigation just on penalty of losing his job. He was required as a condition of his employment to participate in the investigation. Now, Vogt was later criminally prosecuted, not by his police department, but by state prosecutors. And his statements made in the internal investigation were used against him at a preliminary hearing, a probable cause hearing in the criminal prosecution. Now, the charges against him were dismissed, so these statements were never used at trial, but they were used against him at this preliminary hearing. So he has brought this case arguing that his Fifth Amendment rights against self-incrimination were violated because these statements, under Supreme Court precedent, these statements that he had to make as a condition of his employment in the internal investigation are considered compelled statements, and the use of compelled statements in a criminal prosecution violates the Fifth Amendment's right against self-incrimination. That's Vogt's basic argument. The city, on the other hand, argues that this Fifth Amendment right is a trial right. It applies only at trial, not to preliminary hearings, and they argue that extending this to preliminary hearings would have pretty dramatic effects. In any case, that's the basic issue that was the court was going to decide in this case. But already at oral argument, this case was argued back in February. It was clear that from some of the questions from justices that some of the justices weren't too pleased with this particular case as a means of answering this question. There were questions raised by Justice Breyer at the oral argument concerning whether Vogt's statements were ever actually introduced at the preliminary hearing in the first place, and also whether proper objections in that court were made to preserve his constitutional argument. And there was actually a disagreement at oral argument between Justice Breyer and Chief Justice Roberts over whether these factual issues are even relevant to the court's decision in the case. And there were other complications as well relating to an existing precedent which came under question, and just some other factual issues. And there was actually a suggestion at oral argument from Justice Breyer that the court should dig the case, dismiss it, because it just didn't seem like a good vehicle to answer this question. But the question there is then, why did it take so long for the court to actually decide to get rid of the case? As I mentioned, the case was argued back in February. These issues, if those are the issues that prompted this dig, they were raised back then in the oral argument. So why did it take us all the way to the almost the end of May before the court actually got rid of this case? Why didn't they do it right away? So that suggests that there must have been something more to it. Perhaps there were draft opinions going back and forth, some internal back and forth between different justices over the what should be done about this case, how to handle it. But there's really no way to know exactly what was going on in there. There's been some speculation that perhaps this case was actually heading toward a 4-4 split. Now, Justice Gorsuch was recused from this case. He was sitting on the 10th Circuit at the time the case was decided. This case came out of the 10th Circuit. At the time the case was decided below, he was still a 10th Circuit judge and recused, presumably due to some involvement in the case at that time. And so that leaves the possibility that this case could have resulted in a evenly split case. However, if that was the what was going on here, it's not clear why the court wouldn't have just indicated that. When there's a 4-4 split, that leads to a non-precedential affirmance of the lower court's decision by an equally divided court. So the court just indicates without any opinion that the lower court decision is affirmed by an equally divided court, but it's effectively identical in result to a dig. There's really no difference. Basically, the lower court opinion, the lower court decision stands, and then there's no new precedent set by the Supreme Court. So if it really was a 4-4 split going on in there, then why make it look like a dig? Why denote it as a dismissal as improvidently granted? Of course, on the other hand, the fact that the court has stark internal divisions over how to handle a particular case, if that is what was actually going on, it may be the kind of thing that might make a justice think the case is actually a bad vehicle to decide the legal question and maybe shouldn't have been granted in the first place. So these theories aren't necessarily mutually exclusive. But again, this is all pure speculation. This is one of those areas where the court doesn't give any explanation, gives no indication of why it's doing what it's doing. So we're left to just kind of guess. It's the kind of thing that maybe decades from now, when one or more of the justices, long after their retirement, releases some of their internal papers to the public, might shed some light on this, but by that time, it's doubtful anyone will care about this particular case. One more brief case I want to talk about before I get on to the opinions is a case called Planned Parenthood of Arkansas and Eastern Oklahoma v. Jegley. Now, in this week's orders list, the orders list that came out on Tuesday this week after the long 3-day weekend, the orders lists consist of the orders that resulted from last week's private conference, and as always, it includes numerous denials of petitions to the court. There's well over 100 cases that the court denied this week. That's very typical, because if you've been following the court for a while, you know the court only takes something in the ballpark of 1 out of 100 petitions is actually granted to be heard by the court. Now, I usually don't spend much time discussing any of these denials, because the court gives no explanation of why it's denying any particular case. And denial of a cert petition is basically the expected outcome. It's the rare grants that are the exceptional cases, the unusual situations. But there's one denial this week that has been getting a lot of attention, and that is this Planned Parenthood v. Jegley case. Now, this case involved an Arkansas law requiring doctors who prescribe abortion-inducing drugs, and this is referred to as medical abortions as opposed to surgical abortions. It requires those doctors to have an arrangement with a doctor who has admitting privileges at a nearby hospital. Now, this is similar to a Texas law that was declared unconstitutional by the Supreme Court in a case 2 years ago called Whole Women's Health v. Hellerstedt. Now, this case, this Arkansas case, is still in the preliminary stages of litigation in the lower courts, but the Eighth Circuit Court of Appeals had denied a stay of the effect of the statute. So because they've denied that stay, the law will go into effect while the litigation continues. And Planned Parenthood has said that this will have the effect of shutting down two of the only three, there was only 3 abortion providers in the state, and 2 of those 3 would end up being shut down by this, by being unable to comply with the provisions of this law. So they had sought this stay and were asking the court to review this Eighth Circuit decision. Now, the Arkansas law, it's an example of what's referred to often by abortion rights supporters as what's called a TRAP law. That's just an acronym that stands for Targeted Regulation of Abortion Providers. And the Eighth Circuit has been criticized by abortion rights supporters, have criticized the Eighth Circuit's decision as not following the Supreme Court's decision in the Whole Women's Health case. This has been characterized as what's been called a part of a trend of lower courts reading that Whole Women's Health decision very narrowly to provide very little protection for these the abortion providers. So these abortion rights supporters had hoped that the court would reverse the Eighth Circuit and stay the law while the litigation plays out. So as usual, this denial, like the almost all of the court's petition denials, is completely unexplained. So it's again left to pure speculation why the court didn't take the case. Some have speculated that maybe we can read something into this denial, a suggestion about the likelihood that Justice Kennedy, who was the crucial 5th vote in the Whole Women's Health case, the likelihood that he intends to retire at the end of the term. But arguments have been made both ways of why this indicates that Kennedy is likely to remain on the court and still be here next term, why this means that Kennedy is likely to leave the court. It's pure speculation one way or the other. And what's more, there's really no solid reason to think Kennedy will retire this term, apart from his age. Kennedy is 81 years old, which makes him the 2nd oldest justice on the court after the 86-year-old Ruth Bader Ginsburg. Ginsburg, however, has been very clear that she has no intention of stepping down anytime soon. Kennedy has not been so clear, so speculation has been rampant over whether this will be his last year on the court. Of course, the exact same speculation was happening toward the end of last term when many people were convinced that Kennedy was about to announce his retirement, but that did not happen last term. And again, aside from his age, there's no particular reason to believe that he's about to step down anytime soon. So moving on, in this Tuesday's orders list, there were no new grants of cases for next term. No new grants added to the court's docket for next term. So far, the court has granted 18 cases for next term, just due to the briefing schedule, the amount of time it takes for cases to become fully briefed for oral argument. The court basically needs to fill its fall calendar. That's the October, November, and December argument sessions before the court leaves for its summer recess in order to give those cases enough time to be briefed before argument. And to basically fully fill the court's calendar would take about 34 cases. In recent years, the court has not filled its fall calendar. It's had light argument days where it had less arguments than it could have easily placed on its calendar. But right now, with 18. I'm sorry, the feed dropped out again on me, but I'm back. I hope you're still with me. But I was saying that with 18 grants so far, and looking back over the last number of years, I looked back at the statistics for the last 12 terms, and the average number of cases that the court grants in the month of June, the last month before it goes on a summer recess, over those 12 years is about 15 cases. So putting that together with the 18 they've already granted, if they hit that average, that would be 33 cases, which is almost a full fall calendar, which would be more than they've done the last few years. Now, of course, there's a large variance from year to year. That 15 is just an average, and it can be a bit lower or quite a bit higher than that. So we don't really know. We won't know until the end of June how the fall calendar is really going to shape up. But nothing new this week. So that brings me on to the opinions in argued cases. Now, before this week, there were 32 outstanding cases, 32 cases that the court had heard argument in that had not yet been decided, with only 5 weeks left in the term. So in order to clear all of those cases before they go away, they need to average about 6 or 7 opinions per week. But as I mentioned, the court in fact only issued 2 opinions in an argued case and also got rid of a third case. So it's kind of well below that average. So that means as we get closer to the end of the term, these cases are getting more and more concentrated in the last few weeks. So we're going to have some really heavy weeks toward the end of the term. These 2 new opinions and argued cases bring us up to a total of 32 for the term so far. So we finally crossed the halfway mark in terms of opinions and argued cases. We have 32 opinions issued. We have 29 left to come in the next 4 weeks. The 2 opinions issued this week do not include any of the really highly anticipated cases that everybody's been waiting for the end of this term. Now, this term has had a unusually high number of really high profile cases that are either kind of culture war issues or just very divisive partisan political cases. And depending on how you count, I would say there's maybe 8 to 10 cases left that have not been decided yet that I would call high profile big cases. And all of those 8 to 10 cases are still outstanding, still out there, and there's only 4 weeks left. And now, one other thing, the dismissed case that I mentioned earlier, the City of Hayes v. Vote case, that actually drops us down to only 61 opinions expected in argued cases. Now, the court heard oral argument in 63 cases this term. That's a historical low number. But after those arguments, one case, United States v. Microsoft, was dismissed as moot because there was a change in the law. Congress passed a new statute that affected the issue in the case. So that was dismissed. And now the dig today of City of Hayes v. Vote, that brings us down to 61. And this is extremely low. This is really like a historically low number of cases. So it's just an kind of interesting. The court has had a continually declining docket over the last several decades, and this is just shows that trend had not finished. We've gone down even lower than the last several years, which were already by historical standards low. So again, 29 opinions left to go, 4 more weeks left. So the court has to issue more than 7 opinions a week on average to clear these all out before the end of June. There's every expectation that the court will do that. It's been more than 20 years since the court has missed that June deadline. The justices have summer plans all set to go and have no intention, if they can avoid it, of extending their term into July. So we can expect some very heavy weeks loaded with these high-profile cases. So let's move on and talk about the 2 opinions that we got this week. The first of the 2, this is the one that has gotten a little more attention, is a case called Collins v. Virginia. And this is a Fourth Amendment case, and it's about the intersection between 2 different lines of Supreme Court precedents. And the first of these is it's a doctrine known as the automobile exception to the warrant requirement. And this is the idea that when a police officer has probable cause to search an automobile, then that search can be conducted without the need for a warrant. It's typically referred to as the automobile exception. And this comes up in, for example, at a traffic stop. If the police make a traffic stop, they have probable cause to search. They don't need to wait for a warrant. They can just conduct that search. And this is justified by the court in its opinions by the ready mobility of automobiles, the fact that an automobile can be moved easily to a different location. So if the time is needed to obtain a warrant, the car would be gone by the time a warrant was obtained. And also the pervasive regulation of vehicles traveling on public roads, which the court suggested caused a lower expectation of privacy in when someone's operating a car on the public roads. But the second line of Fourth Amendment precedents is about something that's referred to as the curtilage of the home. Now, curtilage is just a strange term, but it's the legal term for the area immediately surrounding and associated with the home. So this is the immediately adjacent to the home, an area that is used kind of as an extension of the home itself. And this area, the curtilage, receives the same protection essentially as the home itself. It's presumptively unreasonable to search the curtilage of a house without a warrant, just like it would be, just like a police officer can't search inside someone's house without a warrant. Now, this decision in Collins v. Virginia, it was an 8-1 decision, so a very lopsided majority, written by Justice Sotomayor. There's a concurrence by Justice Thomas, which is an interesting concurrence, which I'll talk about in a few minutes, and also a dissent by Justice Alito. So briefly, here are the facts of this case. Police in Virginia suspected a man named Ryan Collins of being the driver of a stolen motorcycle that was involved in several high-speed chases, escapes from traffic enforcement officers. Using Facebook photos, the police located this motorcycle parked in the driveway of a home owned by Collins's girlfriend. Now, a police officer went to that address, saw a motorcycle parked in the driveway next to the house, but that motorcycle was under a cover. It was covered up so that the body of the motorcycle couldn't be seen. The officer, who did not have a warrant, went up the driveway to this motorcycle, lifted up the cover, and was able to kind of visually identify the bike, that it looked like the motorcycle they were looking for. And he also checked the VIN number and the license plate on the motorcycle, and confirmed that this was a stolen motorcycle. He subsequently arrested Collins, and Collins was charged with receiving stolen property. So the question here is, was the officer's warrantless entry into the driveway and the lifting of the motorcycle's cover, was that a violation of the Fourth Amendment? So Justice Sotomayor's majority starts by describing the area where this motorcycle was parked. It was the top of a driveway. It was only a few feet away from the side of the house. The area, this particular area of the driveway, was actually enclosed on 3 sides by the house and by 2 brick walls. It was a narrow area, just not much wider than a car. And in that area, there was a direct side door access into the house. However, visitors to the house, the front door of the house, visitors entering by the front door would not pass through this area. So it was not an area that just everyday people coming and going from the house would normally walk through. And you can actually look online. There are photos available that show the motorcycle's location, and so you can actually see what the justices saw, what this driveway looked like. And the court found that this was clearly part of the curtilage. This is the area immediately adjacent to the outside of the house, which was kind of an extension of the house due to the door placement, and it was not an area that the public was normally walking through. And so because of that, this search implicated not only the Fourth Amendment interest in the search of the motorcycle, but also the Fourth Amendment interest in the search of the curtilage. And now, Justice Sotomayor holds that the automobile exception doesn't justify the invasion of the curtilage. She says the scope of this exception extends no farther than the automobile itself. The idea of the automobile exception was that police could search inside an automobile, but it doesn't go to a search of the place where the automobile happens to be located. And she gives a hypothetical. She refers to, what if instead of being in this driveway, the motorcycle was actually parked inside the house, parked in the living room of the house, but visible through a window from the outside. And she says under settled case law, this would still be protected. An officer could not enter the house to look at that motorcycle without having a warrant to enter the house. And Sotomayor also says that the rationales that the court has used to justify the automobile exception don't justify this intrusion into the separate interest in the home in the curtilage. The balancing of interests that's behind the automobile exception doesn't take into account these other privacy interests involved in the home and the curtilage. In her majority opinion, she also distinguishes 2 earlier cases that had been argued to support the government's position. One involved the police who searched the trunk of a car that had had just pulled into an open garage. She distinguishes that on the basis that probable cause already existed on the road, and this is more similar to kind of a hot pursuit case. And the second case involved a search of the bed of a pickup truck, but she said that case never actually established that there was any Fourth Amendment interest in the particular home or the place where that truck was parked, that it was the curtilage, or that there was a Fourth Amendment interest by the owner of the truck in that location. So she kind of distinguishes those cases, says they don't really apply here. And she also goes on to reject a limitation that had been proposed by Virginia. They had argued that the court should limit the scope not to the curtilage as a whole, but to they argued that the threshold of fixed enclosed structures like a garage. So, if this car was parked in the garage, inside a garage, even if the garage door was open, if this motorcycle was inside an open garage, that would be beyond the limits of where police could go. But when it's out in the open, like in this driveway, then that shouldn't be covered. Sotomayor rejects that distinction. She says that curtilage is a well-established concept. It's something officers already are supposed to be aware of when they're conducting searches. And she also says that visibility is not the legally relevant criteria. The fact that the motorcycle was visible from the road doesn't justify entering the curtilage to see additional things that are not visible from the road, for example, underneath the cover on the motorcycle. And she says that this kind of a limitation to inside a fixed enclosed structure would arbitrarily limit these Fourth Amendment rights based on someone's ability to afford an enclosed garage. And in other words, it would give greater Fourth Amendment protections to people on the basis of being living in more affluent areas where cars are more likely to be stored inside. But the majority's opinion does leave open for lower courts to consider whether there may be some other justification for the search, a different exception, for example, like exigent circumstances. That's when there's some emergency that justifies an immediate search. But in general, the court rejects extending the automobile exception into the curtilage of a home and says that a warrant would be required. Now, Justice Alito dissented, and he frames this case differently. Here's Justice Alito, a line from early in his opinion. He says, "The Fourth Amendment prohibits unreasonable searches. What the police did in this case was entirely reasonable." And he compares this same motorcycle that was parked in this driveway to a situation where that same exact motorcycle had been parked at the curb instead of in the driveway. And there, the automobile exception would have applied. The police could have inspected that motorcycle. And he argues basically that this drawing this distinction based on it being 30 feet away up the driveway is not a rational distinction that the court should draw, and says that he points that the officer, quote, "did not damage any property or observe anything along the way that he could not have seen from the street." So he's saying basically that there really is no strong privacy interest that was invaded by walking up the driveway. And he also, the interesting part of his opinion is he disputes the majority's description of the significance of the curtilage in the court's Fourth Amendment case law. He argues that the only reason the curtilage is important is it distinguishes whether the Fourth Amendment applies at all. The area outside of the curtilage, so area on someone's property, but not within the curtilage, not within the immediate surrounding area around the house, that's referred to as an open field. That's just a term that's used to it, the open fields doctrine. And under the court's precedents, the open fields are not subject to the Fourth Amendment at all. There's no Fourth Amendment protection in those. So he says the whole purpose of the court's curtilage precedence is just to establish that the curtilage gets some protection. But he says here there's no dispute that the Fourth Amendment applies in some way. The question is whether the warrant requirement applies. And he says there's really no reason that the house and the curtilage need to be treated identically for purposes of the warrant requirement. Interestingly, though, this portion of his opinion does not cite any cases that support a different treatment of the curtilage from the home itself. So it's kind of he argues that there's no reason to treat these the same, but doesn't seem to have any support from case law that the court has treated these differently in the past. He argues that the rationale for the automobile exception applies equally in the curtilage as it would if the automobile was stopped on the street, and distinguishes Justice Sotomayor's hypothetical situation where the motorcycle was parked inside the house, distinguishes that based on the degree of intrusion involved, and saying that that's a different situation where a warrant would still be required because there's clearly this greater intrusion if an officer was actually entering someone's home. Justice Sotomayor did respond in a lengthy footnote to some of Justice Alito's reasoning, and among other things, accused Justice Alito of basically ignoring the significance of private property in arguing that there's no distinction between a motorcycle parked at the curb and one that's up near the house at the end of a driveway. But moving on, the third opinion in this case is Justice Thomas's concurrence. Now, Justice Thomas joined the majority in full, said it was a correct application of the court's Fourth Amendment law, but he basically said that he disputes the remedy in this case. Now the whole reason, as Justice Thomas points out, the whole reason that this case is in federal court is because of the exclusionary rule. Now, the exclusionary rule is the idea that when the government violates Fourth Amendment rights in conducting a search or seizure, that the evidence that's obtained from that violation can be excluded. It can be prevented from being introduced in court. So the whole reason that Collins is litigating this is because he wants a finding that if his Fourth Amendment rights were violated, that the government can't introduce the fact that he had this stolen motorcycle can't be introduced against him in court because it was an illegal search. And Justice Thomas says, here's a quote, he says, "The assumption that state courts must apply the federal exclusionary rule is legally dubious." And he goes through his reasoning for that. He says that this exclusionary rule, it did not exist early in the country's history. It didn't exist at the time of the Fourth Amendment or at the time of the 14th Amendment. That's relevant because it was the 14th Amendment that made the Fourth Amendment rights apply against state governments, not just the federal governments. But he says at either time, the Fourth or the 14th Amendment, the exclusionary rule just did not exist. Traditionally, the remedy in American law for an unlawful search was a tort suit against the person violating the rights, the police officer who conducted that unlawful search. And he says that the exclusionary rule is just a 20th century development. Most states didn't apply the exclusionary rule until the Supreme Court required it in a 1961 case called Mapp v. Ohio. And he says that historically, the legality of the acquisition of evidence was irrelevant to whether it was admissible in court. Now, he also says that later Supreme Court cases have recognized that this exclusionary rule wasn't a constitutionally mandated rule. Instead, it's a court-crafted prudential rule. He says that the court's opinions have described this as just a court-crafted rule that isn't actually required by the Constitution. And Justice Thomas says, if that's the case, then there's really no justification for requiring the states to follow it. States, according to Justice Thomas, should be free to craft their own remedies to Fourth Amendment violations that may be different from the remedies that the federal courts think are appropriate. Now, this is interesting because this is just an example, and there's been many of these over the years, but it's an example of Justice Thomas's willingness to really strike off on his own and argue that whole areas of the law that have long been considered settled should just be reconsidered from first principles. And this is a repeating theme with Justice Thomas, and he's one of the only justices that really does this on any kind of regular basis. The interesting thing here, though, is, and this is not unusual, no one else is with him here. He's as he often is, all by himself in this opinion. Now, Justice Gorsuch has shown interest in a few cases. He's suggested that he's open to reconsidering certain major areas of law, and he's also shown an interest into really delving into the historical basis for some current practices. But he's nowhere to be seen here. There's no indication that he agrees with Justice Thomas's take. And the majority doesn't really even respond to Justice Thomas at all, which is not unusual for these separate opinions where Thomas is really standing alone. The court, it's not a change in law that appears to have any likelihood of going anywhere anytime soon. So the court doesn't really spend any time addressing it. So that's it for that case. So then that moves us on to the second opinion this week, which is called Lagos v. United States. And this was a unanimous opinion, a short unanimous opinion by Justice Breyer. And this is a case about the interpretation of the Mandatory Victims Restitution Act. It's called the MVRA. And this act, it requires criminal defendants convicted of certain crimes to pay restitution to the victims for certain categories of injuries. And here's briefly, here are the facts in this case. The criminal defendant here was a man named Sergio Lagos, and he controlled a company called Dry Van Logistics. Now, Lagos fraudulently obtained tens of millions of dollars in loans from the General Electric Capital Corporation using forged paperwork. It was forged invoices for services that his company had supposedly provided. Now, as a result of this fraud being uncovered, his company, this Dry Van Logistics, went bankrupt, and Lagos was indicted and ended up pleading guilty to wire fraud. Now, where this case comes down is that under the MVRA, the Mandatory Victims Restitution Act, when someone is sentenced for certain crimes, the judge is required to award restitution for certain categories of harms. So the judge awarded restitution to GE Capital, and one of the things that was included in this award was an award for the expenses incurred in GE Capital's internal investigations of this fraud, and also for GE Capital's participation in the bankruptcy proceedings of Dry Van Logistics. And this amount, the amount at issue in this particular case, is in the ballpark of $5 million in restitution, mostly for professional fees for attorneys, accountants, and consultants. Now, the specific statutory language at issue that's being argued over says that the defendant needs to, and this is a quote, reimburse the victim for lost income and necessary childcare, transportation, and other expenses incurred during participation in the investigation or prosecution of the offense or attendance at proceedings related to the offense. Now, the dispute is over that last part, the expenses incurred during participation in the investigation or prosecution of the offense or attendance at proceedings related to the offense. So the defendant, Lagos, he argues that the word investigation and the word proceedings, those words refer only to the government's investigations and the criminal prosecution. So the proceedings would be attending the criminal prosecution, and participating in the investigation means participating in the government's investigation. Now, the United States and GE Capital, the victim here, they argued that these words are much broader and should cover the expenses that restitution was awarded for here, including GE Capital's internal investigations, which was very costly and they spent a lot of money on. Now, Justice Breyer's majority opinion, again, this is a unanimous opinion, it focuses very closely on the text of this particular provision. It notes that investigation is directly connected with prosecution. It says the investigation or prosecution, which suggests that they're talking about a government criminal investigation, the way it's tied to the criminal prosecution. Similarly, proceedings, which come in the same sentence here, proceedings related to the offense, it suggests that we're talking about the criminal prosecution, because that's what we were just talking about, the criminal prosecution and investigation, and proceedings related to the offense, meaning the criminal proceedings. And the court notes that some of the other words used, the word participation, it says participation isn't a good fit for one's own investigation. It's more natural to say that GE Capital conducted its own investigation, not that it participated in its own investigation. And also attendance doesn't seem like a good fit for participating in civil proceedings. GE Capital didn't just attend the civil proceedings. They want compensation for all of the legal work they did in participating in those proceedings. So they say that the Justice Breyer says basically that these words suggest a much narrower scope for this restitution provision. The court also points to the other things that are covered other than these other expenses. The statute refers to lost income, childcare, and transportation. And it's more natural to read these other expenses as the same type of thing. These are expenses someone would incur in being interviewed by government investigators or testifying at trial. And there's no terms, no other kind of specific terms in these list of types of injuries that are similar to expenses like hiring private investigators or consultants. So the argument is that other expenses should be read to be of the same type. And Justice Breyer specifically refers to a canon of interpretation. That's a kind of a rule of thumb that's used to interpret legal text, and it's one that goes by a Latin name called noscitur a sociis, and which is just a fancy way of saying it's the idea that a word is known by the company it keeps. So when they're talking here about proceedings and investigation, reading this entire sentence as a whole, this entire provision as a whole, kind of gives the context to it and shows the type of expense that they're really talking about. Justice Breyer also talks a little about practical considerations. One thing is that these expenses, the statute only covers, quote, necessary expenses, and says basically if this is limited to participation and attendance that's been requested or required by the government, then the scope of what was necessary participation is pretty clear. But if we extend this to private investigations and legal proceedings, then you might have to have all kinds of collateral litigation over what was really necessary. Were these really necessary expenses? And similarly, it may be difficult in some cases to determine when a particular proceeding is related to the offense. If it's not limited to just the criminal prosecution, how far does this extend? So Breyer just presents that as another consideration that makes the narrower interpretation much cleaner and much easier to apply. He addresses a counter argument made by the other side, arguing that this narrow reading leaves some expenses uncompensated, so some harms suffered by the victim don't get fully compensated. But Breyer notes that Congress has passed a number of different restitution statutes, and these different statutes have differing coverage. Some cover more, some cover less than others. Unlike some of these restitution statutes, the MVRA doesn't say that it covers the victim's losses in full. It only covers specifically identified losses and expenses that are spelled out in these particular provisions. And Breyer also notes that there's one other restitution statute that explicitly covers, quote, the value of the time reasonably spent by the victim in an attempt to remediate the intended or actual harm incurred by the victim from the offense. And that would seem to cover this kind of expenses related to internal investigations, but there's nothing like that in this particular restitution statute. And Breyer also notes that there are other remedies available. And in this case, GE Capital actually did bring a civil suit and was awarded more than $30 million in damages. Breyer notes that apparently GE Capital has been largely unable to collect this money, but he says there's no reason to think that a restitution award would be any better in that respect. One final argument he addresses is GE Capital's argument that they shared the results of this investigation with the government, and therefore this should bring it within the scope of the government's investigation. But Breyer responds to that actually the statute says expenses incurred during participation in the investigation, and GE's own investigation was before the government's investigation, which just isn't within the language of the statute. Now, the court leaves open whether similar types of investigative expenses might be covered if they were incurred at the government's request. If the government had asked GE Capital to conduct its own investigation into this, maybe would that be covered? The court leaves that as an open question. So an interesting thing about this opinion, it's a short opinion, but it's a thoroughly textualist opinion. And textualism refers to an approach to interpreting legal texts where there's a heavy focus on the specific words of the statute, the actual language that's used, the context of that language, how different words and phrases and sections interrelate with each other, and looking at just focusing on that specific text in order to determine meaning. And under a textualist approach, judges don't resort to things like the broad purposes that were motivating a statute, the broad things that a statute was aimed to achieve, and doesn't ask whether members of Congress would have wanted these particular expenses to be covered. They just look at whether the actual language should be best read to cover, just by the a fair reading of that language. And this is a very common approach for this court. Justice Breyer is often described as the least textualist of the current justices, the most likely to want to look to these broader purposes or congressional intent. But as this opinion shows, even he's willing to write a thoroughly textualist opinion that seems to be driven almost exclusively by the language of the statute itself. And it's just an interesting illustration of how textualism has really become the dominant approach to statutory interpretation at the Supreme Court. Live stream time, Thursdays at 9 p.m. Eastern. And you can always check the Counting to 5 YouTube channel to find the next scheduled live stream. Now, next week's live stream, the court held its private conference for this week earlier today, and an orders list will be issued Monday morning at 9:30 coming out of that conference. And so we may see some more cases granted for next term in that orders list. And according to the court's public information office, opinions are also expected Monday morning. That would be issued at 10 a.m. The court has not announced any additional opinion so far, no additional opinion days for next week. So it'll just be Monday that we're expecting some more opinions from the court. And just as a reminder, there's only 4 weeks left of the term and 29 cases still outstanding. That means the court's got to get through, on average, 7 to 8 cases a week. It's almost certain that the court will add additional decision days later in June. It won't issue opinions only on Mondays, but we'll add an additional day or two to get some additional other opinions out. Just based on past practice, the court rarely, if ever, issues more than, say, 5 or 6 opinions in a single day. And so if they stick with that practice, they'll need to add additional days to get all of these opinions out. And as I mentioned before, this case has an unusual number of kind of really high-profile major cases. And of those major cases, really only 2 of the highly anticipated cases have been decided so far. That's the Murphy v. NCAA sports betting case, and the Epic Systems. That's the case about the enforceability of employment arbitration class waiver provisions. And those cases have been decided, but the rest of the major cases, and again, there's depending on how you count, 8 to 10 of them, they're all still pending. So we're going to have a lot of big cases coming down in a very short period of time. We're going to have some busy weeks going forward. I don't know whether I'll be able to cover everything in these weekly live streams. I may either have to give very abbreviated descriptions of the cases, or potentially I'll split things up and add additional live stream days where I cover some of these opinions. I'm not really sure how I'll approach that going forward, but we'll see. But in any case, next week it looks like we'll just have opinions coming down Monday. So planning the live stream as usual next Thursday. Whether you're watching on YouTube or listening to the audio podcast, I would love your feedback. You can leave comments on the show notes at countingto5.com, on the Counting to 5 YouTube channel or Facebook page. You can tweet at countingto5 or send an email to mike@countingto5.com. Please subscribe to the Counting to 5 YouTube channel or audio podcast to make sure you don't miss future episodes. Thank you for listening. This has been Counting to 5.